Welcome back to Hashtag Lawyered, everyone. Today, by popular demand, we have pet trust in the house, and normal trust too. But pet trust is the most exciting part. Anyway, get ready to take some notes. Welcome back, y'all. You have the legal A team in the house.
Here we are.
Yes, and then we also have my husband, Spencer.
I'm back.
First recurring guest, which you're a recurring guest now, which means anytime we ask you to come on the show, you have to.
You have to come on.
Gotcha.
It's a recurring guest rule,
Yeah.
secret rule of podcasting. So just letting you know, it's official too, because now we've got it on film.
Good to know.
Yeah.
Didn't know about that rule. I just thought it was, an honor that I could get to come back, and then you didn't kick me out after the last performance.
Well, the followers, I had a poll go out, and the followers said 100% unanimous that they wanted you back for pet trust. So.
Wow. Okay. Usually I get crickets after talking about probate.
Oh, well.
Another morbid joke. I'm sorry.
Yes. Well, today we are talking about fun things, living things, like
Yes.
pets and other people. But the pets are more important. Anyway.
Well, and you got to lead it. You got to tell the motivation for why we're doing this about the pet trust. You got to give a little lead in, and we're going to have some video footage for our viewers to watch later.
Yes.
Okay, so y'all, recently Spencer and I welcomed a little puppy into our family. She's a golden retriever. Her name is Stella. Stella Steffens Turner. She's really sweet. We were going to bring her into the studio today, but she's still a little, she likes to chew things still.
My hands, mostly.
His hands,
Got a
mostly.
lot of electronics in here, so
We do have a lot of
too,
electronics,
yeah.
and last night she kept trying to walk towards the cord for the lamp by our couch, and I was like, you know what? There's a lot of cameras in here. I don't want to give Matt a heart attack.
Yeah.
So maybe let's just splice in some video.
Yeah, we'll get some video in there though.
Yeah.
Be able to
Yeah.
show off the motivation for the episode.
And of course,
Absolutely.
Bella Luna is just as important. My cat. She is also
Yeah, absolutely.
Lest we
Also
forget
in there.
about her.
yes,
So,
my firstborn pet, if you will, in this Turner household. But anyway, motivation are the pets. But to understand pet trust, I think you really need to understand regular trust.
Sure.
So, Spencer, we are here to learn all about trust. My selfish reasons I want to know more about pet trust. But anyway, so we've discussed that you've been here before. Kind of give us a brief recap of what you talked about last time.
yeah, last time I was here, we got to talk about the amazing world of probate. And not just probate, but also as a kind of an ancillary matter, why you need a will. And why a will is so important to the probate world. And I think in the middle of that discussion, in talking about wills, you inevitably start talking about the other really important estate planning vehicle, which are trusts. And just what those are, we never really got to cover that subject. And so born out of that was the discussion about maybe coming on here and talking a little bit about what these mythical trusts are that people seem to talk about all the time.
Well, and you say mythical, I mean, quite frankly, that's something, I'm going to be learning just as much as our listeners are today. Had to learn a little bit about it in law school, but
Yeah.
trust, as you know from our conversations, just from being friends and everything, I just kind of say, yeah, Spencer, whatever you think. I don't know anything about this stuff. So I'm going to be learning just as much. But one thing that I do think is important for people to understand is that a lot of times when you're doing estate planning, when you're putting a will together, planning for your death, trusts are something that usually are interwoven, and most of the times you're usually recommending a trust somewhere in that process too. Is that an accurate statement?
It really depends upon the client, the assets, the personality of the client, the goals, all the above. But yes, anytime you're doing an estate plan, usually the first question, or not even the first question, the first point that I talk with a client is you can go down the will-based route, or you can go down a trust-based route. And sometimes you can go down a will-based route and still have trust built into your will.
Yeah.
So you'll see that there's a ton of flexibility with how you build a trust, with who serves in the trust, with how it works, all the above. And that's kind of the devil's in the details, of course, and that works with anything, but very much.
Trust. We've heard this term thrown around so much already today in the episode, and then we've heard it thrown around in real life, right? Trust fund babies, hey gossip girl looking at you. And anyway, so for those of our listeners who are like, what the flip is a trust?
Yeah.
What is a trust?
Okay.
Break it down.
All right. So a trust is an agreement between three parties. So think of it this way. At the beginning of this entire situation, you've got one person that has the money or the property. And we refer to them as the grantor or the settlor. You'll probably hear it either way. And the settlor or grantor entrusts the money to a trustee, the second party. So, and that trustee holds the money, manages it, uses it, invests it, distributes it for the benefit of a beneficiary. So there's your three parties right there.
Okay.
And that is essentially what a trust is. It can be as simple as just simply, Andrea hands me $5 and says, I entrust this to you to hold for the benefit of Austin. That's as simple trust as you can find.
Let's be real. It would be for the benefit of Stella, but you know.
Right. Well, of course. Yeah. In going with the theme of pet trust, yes, it'd be for Stella.
There we go.
But that is as simple as a trust can be. It can also be extremely complex. Social Security Administration and the Social Security Trust, it's quite literally a trust handling trillions of dollars, or it may not be trillions anymore.
I actually never thought of it that way.
Yeah, I never did either.
Oh.
Yeah. I mean, and again, there's a lot of statutes and a lot of regulations that go into how that trust operates.
Right.
But at the core principle, it's a trust.
Yeah.
The government is holding on to property that is collected, and the beneficiaries are individuals that meet certain criteria that are to receive the benefits of that trust. So it's not an uncommon thing. You see it everywhere in society. But the core principle is that little agreement between three parties.
And so kind of for illustrative purposes, and I'm going to use some very stereotypical, fake characters here, but you've got rich grandpa would usually be the settler. He would be the one that the grantor that has the money.
The stereotypical.
Right. And then he appoints the responsible older brother as the trustee to maybe benefit, or the responsible older son to benefit and run the trust for the beneficiaries, which are his grandkids.
Yeah, and that's a frequent context that you find it in. You can find it in a variety of contexts, and it really depends, again, on what your goals are. Trusts accomplish a variety of different goals because they're so flexible. It's a core concept, but you can use it in so many different kinds of areas and for purposes.
And so speaking of all the different areas that you can use trusts in, what are the primary roles that trusts play?
They play everything from, well, let me rephrase it this way. As an estate planner, and an individual that runs across trusts frequently, they're used for everything from asset protection to helping with, especially your estate taxes, to the management of property, to concerns of incapacity, and frequently trying to avoid the probate process. And that's not necessarily a bad thing when I use the word avoid probate process. People hear avoid and they usually throw taxes right beside it.
Right.
So why do you want to avoid the probate process? Does it matter, like here in Texas, more so than any other states?
Not so much in Texas. The classic example I run into is client comes into the office and they've got a Colorado mountain lodge, or not lodge, but some sort of mountain cabin.
A chalet.
Sure. One of those, very nice up there in Colorado. And they've also got a Florida beach house, and if they were to pass away and they only had a will here in Texas, you would obviously go through the probate process we talked about a few weeks ago in Texas, but then you would also have to take the will up to Colorado and go through the probate process there for their Colorado mountain lodge, chalet, whatever it might be.
Sure.
And then you'd also have to go to Florida. And those are two different systems. You require different attorneys or local counsel in Florida and Colorado to do so. The way that you can kind of get around that is you put those properties in a trust, and that trust, when you pass away, the trust holds the properties and they're held for the benefit of maybe your kids, your grandkids, whoever it might be. And at that point, you don't have to go through the probate process in those states. So there's a benefit to that, and then that's one of many. And there's obviously drawbacks as well to having trusts.
Sure.
Absolutely. So Austin gave us the example earlier of rich grandpa setting up a trust, right, for the beneficiary or benefit, of the grandchildren.
Yes.
And presumably that would have been woven into his will, right? Is that what you were thinking?
That's what I was thinking.
Yes.
Mine,
Yeah, it's frequent.
Okay, sure. So can you have a trust independent of a will?
Absolutely. So you certainly can. Trusts can be in any kind of agreement that you can find and in writing. If they're going to hold real estate, they need to be in writing. But you frequently can have what we call a trust instrument. And it's as big as you want it to be. It's as small as you want it to be. It can be simple enough as I've seen a one-page trust, instrument back in the 30s, and it's still going today. I've seen a draft frequently, 45, 50-page trusts, and that's pretty normal. There's just a lot of different language that has to go in it. Kind of what you need to understand about when you put together a trust, the purpose and goal behind the trust is important because the trustee, when you give the property, the grantor initially gives the property to the trustee. The trustee has to abide by certain standards as to how they're giving and distributing property for the benefit of those beneficiaries.
Right.
And those standards require a lot of explanation, a lot of consideration for a lot of different reasons: asset protection, tax concerns, you name it. So it's not hard to recognize as you get further down into understanding what trusts are, how much language can go into these documents and how voluminous they can become.
Yeah, and then you mentioned the trustee has a duty to make sure he or she is managing the assets in a way that is beneficial to the beneficiaries, and the trustee can actually be sued for breaching that fiduciary duty. I mean, you and I have actually been involved working together in a lawsuit for a trustee that breached his or her fiduciary duty. And so that's kind of the hammer that the beneficiaries have if the trustee's not doing their job, right?
Right.
And that can get those can get ugly because a lot of times you have family members that are running the trust, and it can be an ugly fight. And one of the things that I learned a lot working in that case when we were working together. I mean, there's a pretty high standard for what the trustees expected to do, and the things they need to be doing to maintain competency and be managing the funds and the money and the distributions and all that kind of stuff. And it's probably not the best idea, especially in a more sophisticated trust, to have somebody who is not well versed in these types of activities to be in that position, right?
And that's what I have to tell clients. So let me talk about just generally how the discussion of trusts come up in my practice. When a client comes in and they're talking about, let's say, their estate plan and what they want to do to establish an estate plan that puts forth their legacy for many years to come. Inevitably, the discussion comes up while they're determining what they want. They have kids. Sometimes the kids make decisions that they don't agree with. It may be the choice of a spouse. It may be they're a spendthrift, as we kind of call in the law.
What's a spendthrift?
Somebody who just spends money wantonly. That has no regard for resources or responsibility with those resources.
Sure.
So those kind of circumstances lend to a situation where I'll tell the client, well, there is a way to control from the grave. And this kind of gets into a distinction of where trusts kind of split. You can have a trust during your lifetime. We call those inter vivos trusts.
Among the living.
Yeah, among the living. Thank you. You studied Latin more than I did.
5 years.
Or we have testamentary trusts, where trusts that happen after you pass away. And I'll tell clients frequently, it is possible to, if you have Andrea, for example, I'll use us. If you and I are married and the second of us...
If we are married.
Yeah. Well, I'm using it as a hypothetical in that if we're married and developing an estate plan, I know, really.
Careful, Spencer.
Careful. I didn't have enough coffee this morning. I want to quickly point that out. So, well, already got the foot in the mouth.
Mom
Austin,
and Dad
it's
are
a good
fighting.
start.
This is real fun for me right now.
I know. Austin's sitting over on the side going, man, what did I get myself into? So, but as the hypothetical goes, if you're the second to pass away and you have a will, and we have 2 kids, and they each get 50% of our estate, and during the course of their lifetimes, we had grown concerned that they had either married the wrong spouse or just have no regard for how to be responsible.
Yeah, she really shouldn't have married that up-and-coming rock and roll star.
That's right.
I mean, and that genre is just dying.
He never got out of his garage playing his guitar,
No,
and
didn't.
so in that circumstance, I'll tell clients, you can put their 50% in a trust. So what that would look like was, upon death of the second spouse, the child's half of the property goes into a trust for their benefit. Somebody's going to serve as the trustee of that trust. Maybe it's Uncle Joe, maybe it's Aunt Velma.
No, it will be my mother.
It will be, without a doubt, your mother.
Delara Deal
Yes.
knows exactly how to run these sorts of things.
Well, and your mother would be the trustee. She would distribute, any property or money, funds from that trust to that child's benefit for their lifetime.
Yeah.
And
She
the
would be
purpose,
good at it.
I have no doubt.
Oh, yes.
And the purpose of that would be you protect the child from their lifestyle. When you have a trust set up like that, where it's in a will, the will quite literally has a section that says this is the trust for child A.
Sure.
And at that point, the child only gets distributions in accordance with these and these terms.
What are distributions?
So distributions are payments from the trust, basically. The trustee can sometimes write a check. They can maybe just pay the the debt or the utility bill of said individual, the rent, the mortgage, you name it. It's
So,
any
like,
kind of.
for example, they could do a direct deposit into the child's bank account. You get $500 for spending, and then the trust does automatic payments to utility, water, internet, and rent.
Absolutely. You can do all of those things. And the trick about how you distribute property and the methods and the standards with which you should distribute is that it can affect the asset protection purposes of that trust. So when you build a trust like that in a will that's taking place for your child, that has what we call asset protection. If our child were to have a $50,000 credit card bill that he built up or she built up over time, the credit card company and their collection agency cannot come and take that $50,000 out of that trust, out of their half that's being held in trust. Right. Now, obviously, if it's distributed to the child, it's free game usually at that point. Right. But if now the trust were to say something along the lines of, they take as much as they want, well, then it's a whole different discussion. The law looks at that a little differently. Go ahead.
So now, actually, I'm glad you brought that up, right? So there's a distinction. So there are more than one type of trust.
Right. There's a lot of trusts.
There are a lot of trusts, but what are the two big dividers in trust law?
After inter vivos and testamentary,
of course,
you get into the discussion about what is revocable versus what is irrevocable. And they kind of have different consequences for what the trust's role is and what the trust ultimately is able to accomplish as a result. So revocable is obviously a trust that's, you can revoke it. It can be just all washed away right then and there.
Done. So I'm over it.
And there's a context that usually shows up in.
And what's that context?
So it's in estate planning, and most people have probably heard of it at some point or another at the family dinner table. Discussing Great Aunt Harriet's her family revocable trust, or revocable living trust, or revocable as some people might call it. And what it really is you've got the three parties that make up the trust agreement. And for a revocable living trust that you always hear about, you hear people throw around, it basically is the same, people are the grantors, the trustees, and the beneficiaries. They serve all three roles at once. They're wearing three hats at the same time.
It's a lot of hats.
It's a lot of hats.
I hope they color coordinate.
So do I. So, and when you have that kind of trust, you set it up during your lifetime. So it is an inter vivos trust. But at any point when that trust is set up, they can revoke it. Now, when the people that set it up, who are the trustees, who are the beneficiaries, and they're benefiting from it their entire lifetime.
Great Aunt Harriet.
Right, Great Aunt Harriet and her husband. When they both die, that trust, if it continues on, may they rest in peace, Great Aunt Harriet. And did we name the uncle?
He doesn't need a name. He's
okay. We don't have to worry about him.
It's just Great Aunt Harriet.
I know you and names and hypotheticals. I have to be careful.
I do love them.
They're all across the board sometimes. So,
they are. You got to keep up.
But at that point, it becomes an irrevocable trust, where when you die, you can't just revoke a trust. A, there's no one to revoke a trust. B, who do you revoke it and it goes to? They're not there anymore. So at that point, when it's irrevocable, it can, shocker, not be revoked.
So this is controlling from the grave.
Right. This is when it becomes controlling from the grave.
Great, now, Matt, let's cue the Halloween music, please. Do some Twilight Zone. No, I'm kidding.
Now, I will say this. You can make an irrevocable trust from the get-go.
Sure.
You can create a trust where I give property to Andrea as trustee for Austin's benefit, and I say that it's irrevocable. And the reason why you would do that is usually for tax purposes. If I, have a large estate, there's going to be a situation where I may want to get assets out of my estate, because eventually when I pass away, that might push me over the estate tax exemption limit. So those are the kind of situations that you would do it. But it's also for asset protection purposes.
Yeah, because we deal with this in litigation all the time, where you get a judgment and people want to know what of my assets are protected.
Yes.
And if they've set up a trust, and we won't get into fraudulent transfers and all that.
Oh gosh,
that's a whole other episode.
But if they've set up a trust and then 20 years later their company gets sued and they pierce through it and they've got some personal liability. Well, that irrevocable trust could protect some of the assets that maybe would be open to creditors who have a judgment against them to go after.
Exactly right.
That's a great tool there for asset protection while you're alive.
Yes,
because it keeps it away from people to sue you.
And that's true. And I get that comment a lot from clients. Like, let's just put it all in a trust, and and that protects it, right? And it doesn't. It does not immediately, because what clients and most people don't seem to realize, trusts are a sliding scale of control versus asset protection. If you want the asset protection in a trust, you're going to have to give up a significant amount of control. And what I mean by that is if I have a significant amount of property and I turn around and I give it to Andrea's trustee to take care of for you, obviously it's no longer mine. I don't
So that
get
50,000 acre ranch that I've been talking about?
Yes, that one. Yeah. That we're somehow going to pay for. You know?
Yes, well, I'm hoping I win the lottery. No, I'm kidding.
Right. I mean, it's obviously asset protected at that point. Yes, I'd love for you to win the lottery. I think it'd work great for all of us.
In taxes, so.
Well, and in policy though, it makes sense because you're giving up complete control benefit of it, and so then it's like, well, okay, that's okay. They gave it up, so that's protected. As a creditor, I can't come after it.
Right. That's the very idea of it. And it works the same way in the will, in the scenario we just mentioned about child A, who's the spendthrift, and it has this credit card company that's trying to come after their assets. It's the exact same scenario. You've created a trust for their benefit that's never coming back to you. It's never at any point going to have some sort of interest in it that would, potentially ruin those asset protection opportunities. Go ahead. I'm sorry.
I was just going to say, if you keep going, if you weren't done
There
with
was
that.
one other thing that really is really important and is why people, choose trusts. And this is kind of the little, what you hang your hat on at the end of the day as an estate planning attorney. Irrevocable trusts, especially testamentary trusts, not so much, lifetime irrevocable trusts, are typically divorce proof in Texas.
Yes,
so child A marries a schmuck.
Schmuck, I love that word.
Yeah, I love that word too. And marries just a true blue schmuck, and it's obvious schmuck A wants to get hers or his and get out. When you put the half of their inheritance in a trust, schmuck A cannot come in a divorce proceeding and take what's in the trust. That is considered separate property. It's not divisible by a divorce court. And Austin, I know you run across this all the time, and Andrea, you've ran across it in the past. And so that's a huge point for people, and a big reason why they do put together trusts, testamentary trusts especially. It's a little less certain when you're doing it during your lifetime. You run into the fraud issue if you're starting to do that before a divorce. But that's a big reason why people implement trusts in their estate plans.
Well, and it's not, and I won't go down the family law rabbit hole, but that's a big part of it too, because technically, if you receive something through inheritance, that's going to, by rule, typically be separate property. But problem is you end up with these other, you start commingling with your bank accounts, all that kind of stuff.
Dividends.
The trust is kind of the belts and suspenders purpose or part of it, where you tie it all the way up to where it's all taken care of, to where the spouse through the divorce can't climb through that and try to say stuff's been mixed and matched, because the trustee is the one managing the money.
And the law is not completely settled on that. The cases that have put that into motion are still unclear about the distributions that come from those trusts, about certain investments within the trust. So that may change, but for now, they're divorce proof. And I have a lot of clients that really appreciate that they can protect their children from decisions, because at the end of the day, 50% of marriages ended in divorce. And I mean, the statistics are what they are.
Depressing.
So I know.
That being said, are trust fund babies real?
Trust fund babies are very real. Do
I have to be a Procter & Gamble heiress?
Not necessarily. You can be a trust fund baby if you've got $50,000 in a trust that's being held for you since your parents' passing. I mean, that is technically under the term. But I mean, we all think of, when we think of trust fund babies, the kids in LA running around, Gossip Girl, right? I don't know why I immediately think of LA, but
I was about to say, I'm not sure why you think of LA.
I think we were watching some show on Netflix, and there, the trust
Bling
fund
Empire.
That's what it was.
It is interesting.
So yes, trust fund babies are real. They have a large amount of money, at least in what the context we think of them as, and that money's held away in a trust, and it's good planning on the part of their parents.
Well, you think of Gossip Girl, you think of LA. I think of a handful of my clients that I've dealt with through divorce processes, and those are always interesting.
Yes, they are. There's a whole different package that comes with all of it, and that's great. Their parents thought ahead and thought carefully. So.
Good job for them. Okay. Rapid fire. Top 3 perks of a revocable trust.
Okay, so a revocable trust the reason why you would set it up is A, to avoid probate.
Okay.
Now, I mean, that's the sole, not sole, but it's a big function.
Okay.
There's also privacy that comes with trusts. You know, you're able to keep your name off the title of most of the assets and make it the trust. So you could say XYZ Family Trust. No one knows who the heck is actually part of XYZ Family Trust, you know. And then on top of that, there's incapacity concerns, the ability to have a backup trustee jump in and take care of your assets if both you and your spouse have COVID and are in the hospital for 6 weeks and you know, on a ventilator. You know, those kind of things people really appreciate. Revocable trusts.
Okay. And as to irrevocable?
Irrevocable, you see most often in asset protection, divorce proof, and tax planning. Those are the big three.
Controlling from the grave.
Controlling from the grave is a real thing. And you know what? There are circumstances it is highly warranted. It's not as dirty as what people want to say.
All right. And then, Austin, did you want to ask about some misconceptions?
Yeah, and I think we've covered a few that we've talked about, but you mentioned earlier one of the big misconceptions is that if I put my assets in a trust, they'll be protected. Right. And can you kind of explain in certain situations where that's not necessarily the case?
Right. The classic situation is the revocable living trust. You know, clients come in and they go, well, let's just put it all in a trust, but I still want to enjoy the assets and use them. And you're like, well, that's not how this works. You don't get to have what we call a self-settled trust, where you are the grantor, you take your property, you give it to yourself as trustee, and then you're just going to use it for your benefit as beneficiary. That doesn't work. The law doesn't consider that to be a protected trust.
Well, it sounds an awful lot like a revocable trust when Great Aunt Harriet is wearing 3 hats at one time.
Right. That's exactly what it is. And in those situations, you don't have any asset protection. And you may not even have asset protection when you give yourself the assets as trustee for the benefit of your kid, because you're still the trustee. You're still controlling legal title. You may not be actually having the benefit of the title. But so those kind of circumstances don't work in your favor. It's going to have to be a situation where you make a irrevocable trust, you name someone else as the trustee, and you're having it for the benefit of probably your family, you know, some member in your family.
All right.
Well, and it's kind of the policy idea is again, if we're trying to give you creditor protection, you can't still kind of control the pot.
Right. It makes sense if you start thinking about it. You know, if you're wearing the same 3 hats, then what's the difference of you owning it? In fact, tax law doesn't even look at it as a different entity.
Yeah.
You know, revocable living trust is a disregarded entity for tax purposes. So if the tax doesn't even consider it separate, why would property law consider it to be something that actually is a vehicle that protects assets? Right. So it's logical.
So, Spencer, can I hide things in a trust? Say I bought a really cool Cessna and I don't want anyone to know that I own it. Can I put that in a trust and hide it?
You can create privacy, but you can't necessarily just hide things. I mean, there are private investigators out there that know how to search for stuff. You know, it's not like an offshore company, so to
Swiss
speak.
bank account, perhaps?
Or not a Swiss bank account. Lord, we don't want to get into that discussion. So
another time.
Well, and I think that one other thing we talked about, and we touched on it earlier, is that when you put something in a trust, you can't just leave it there and let it sit.
Oh, that's a big point. Trusts are not just something that you construct and go, cool, put that to the side and that stays there and it's good to go. It's my trophy. Right. It doesn't work that way at all. They require continuing administration, which therefore requires both cost, time, effort. Frankly, if you have anything of a complex trust, you're probably having to consult your attorney repeatedly on it. So there is a lot of maintenance that comes with putting together trusts. And you need to consider that on the front side before you really dive into trying to put one together or at least implement one in your life.
Now, my favorite part. Oh, did you have a question?
Go ahead.
My favorite part, pet trust. Okay, I was about to say, we're about to close in on our last 6 minutes on air. So I want to make sure we talk about pet trust.
Of course.
I want to make sure Bo, Linda, and Stella are taken care of.
But of course.
So what is a pet trust?
Well, a pet trust is a trust, and it fits the very core principle of what it is. It's usually, this is the context I see it in. Somebody is passing away. They have several pets, and they name a trustee to have a certain amount of money and to take care of those pets and use that money for the benefit of the pets. So there's 3 parties. The pets just end up being one of the parties. So it's fairly simple and straightforward. I've drafted a couple of them, for clients. Usually,
I'm still waiting on mine.
I know you are.
So,
you have made me aware. So it's, let's use the example of Bella Luna and Stella. How's that?
Our girls.
Yes, our girls. So at the second of us to pass away in our wills, we could have a trust that says I give X amount of dollars to, let's say
Rachel.
Rachel, one of your best friends, Rachel. And Rachel is to take care of Bella and Stella, and for the duration of their lifetime. And the amount that you give Rachel really is going to depend upon how much does a pet cost per month. And that's going to vary from each pet. And then you're also going to think about, well, how long will those pets live?
And do they have any medical conditions?
Right. You're going to need to think about their medical conditions, how frequently they go to the vet, all the different, much like what you would consider with a person, what are their lifestyle? Sure. All the above. And you'd be amazed the amount of money that this can add up to be, and so tens of thousands of dollars later, the trustee, and I've seen these pet trusts get quite complicated. They're telling that every Monday, Wednesday, and Friday, you need to be, walking the dog in this direction. You need such and such caretaker to take care of the pets. I mean, people love their pets, and understandably so. So these trusts are sometimes very creatively crafted to make sure that the trustee, hires a very careful caretaker, for these pets. And, there's also consideration on sometimes the sum of money that's been given is large. So after Stella and Bella are gone, not to think about that. But after they're gone, who does it go to then?
Right.
And sometimes actually several states have enacted statutes about how, about these trusts, at least enabling the ability to create trusts for the animals and then providing what the default terms and conditions are.
Interesting. Is Texas one of those states?
I have not seen a statute in Texas yet that talks about pet trusts.
All right, so Texas legislature, get on that, please.
Right. But Oregon definitely has, which shouldn't surprise anybody. Oregon actually
surprised.
has a federal district court that has recognized pets as more than property, but not quite human statute. Statute.
That's cool.
I don't remember, and this was years ago. I haven't looked at the case in a while. But they have recognized that. So it's not any surprise that the Oregon legislature has created that kind of statute.
And that's important, right? Because in Texas, but for one itty-bitty case that is a slight deviation, animals have always been considered property.
Yes, primarily. I mean, you see it in the divorce decrees.
Right, yeah, because you can't, in family law, you can't have custody over a pet. There's no custody fight. They are considered property, and it's divided as such. Now, in this situation, though, and this is just my mind thinking it through, you could set up a similar trust for what we would consider in Texas property. So say you had a piece of real property, you could set up the same type of trust that says you're going to fund and maintain this piece of real property to a certain standard. So it's kind of the same idea. Sorry, I'm taking the caring and sensitive human element.
Well, you know what? Here, this property is for the benefit of Stella to run around on.
Yeah. You
chase butterflies along with Bella Luna.
I've not seen that grandiose of a design, but yes, you could pull off a trust that way.
Now, I've got a question for you that just popped up in my head.
Yeah.
Obviously, the beneficiaries of this trust are the pets.
Yeah.
And typically, in a trust situation, you've got the trustee mismanaging assets that beneficiary can sue them for breaching fiduciary duty.
Great point.
So how does this work? Who sues on behalf of the pets if they're not getting walked enough each week?
It's a really good point. And, there's probably something to the effect of an interested person.
Okay.
There's frequently, at least in like a guardianship context in Texas, the interested person can step up and say, this isn't right. We either need a guardianship or don't need a guardianship. Right. I think the same principle applies for the pets. Whoever's interested in the welfare of the pets is probably going to be able to present some sort of breach of fiduciary duty claim that the trustee's not taking care of them. More than likely embezzling, the funds. Right. That'd be the context I would think. Yeah. And it's not hard to consider when you think about it. Yeah. Best friends kind of going, are you kidding me? These dogs just got $100,000.
Right.
They're not gonna miss, $45,000 of it.
Yeah.
Well, good thing Rachel would never do that.
No, I know Rachel would never do that. But that's a very real concern. And I've not ran across that kind of situation before. But there's no question it's gonna happen.
Yeah.
So the moral of the story is, y'all, pick your pet trustees carefully.
Absolutely. Pick your trustees, period, carefully. Yeah. And that's probably one of the greatest deterrents of trusts is, outside of yourselves being named as trustee, you really have to pick carefully who's going to be that trustee.
And on that final wise word, Spencer, thank you so much for coming on air and discussing pet trusts.
For having me.
I am eagerly awaiting Stella and Bella Luna's pet trust. Love you.
It's coming.
All right, y'all. Hope you enjoyed. Stay tuned for Closing Argument. It involves Joe Exotic. Meow.
Thank you guys again for listening to us here on #Lawyered. Go find us on whatever platform it is that you listen to your podcasts. Go like the podcast, go follow and subscribe to us. Leave us a review, leave us a rating. That helps us to really get the word out and really continue to tell you guys about all the different things that are going on in law and business here in Dallas. Make sure you check out our videos on our YouTube channel. It's #Lawyered. And then also follow us on our Instagram account. It's at #Lawyered. DM us, send us some issues, some topics you'd like to discuss, or some things that maybe you just don't understand about the law, because we want to make sure and cover and give you what it is you want to listen to.
Well, y'all not sound like a Christmas song, but President Trump issued 73 pardons and 70 commutations of sentences. And guess who was not in that statistic? That's right, Tiger King himself. The former zookeeper was extremely disappointed to learn that he was still going to be hanging out in jail. That stretch limo his team had waiting outside to whisk him away didn't get used. Well, hope he's working on his pitch to President Biden.